And to join with me in welcoming our second speaker for this session, Dr. Mark Fowler, who is an adjunct associate professor at both the University of New England School of Law and also the University of Notre Dame School of Law, as well as being the principal of Fowler Charity Law, a member of the Australian Charities and Not-for-Profits Commission's Advisor Forum, and an appeals panel member for the Australian Council for International Development. He'll be speaking with us today about the proposal for an Australian Human Rights Act, a critique of pure human rights reasoning, and I'd ask you to join with me in warmly welcoming him to the stage.
Thanks very much, Lorraine. I'll just get myself sorted here. Thank you, Ben, also for your very considered comments. So thank you to Xavier and to the committee for the invitation to address you today. I've chosen to address the topic, the proposal for an Australian Human Rights Act, a critique of pure human rights reason. The date of this conference is timely, as Xavier observed this morning, given that a Commonwealth parliamentary inquiry considering the Australian Human Rights Commission's proposal for Australian Human Rights Act is due to deliver its final report next Thursday. Given the wide-ranging implications for the rule of law and the accountability of power in this country, the scant consideration afforded the proposed ARA in the media to date is nothing short of astonishing. The philosophers among you will notice in the title to this talk the regard paid to Immanuel Kant's The Critique of Pure Reason. Drawing upon my evidence to the Commonwealth Parliamentary Inquiry considering the ARA, in this lecture I intend to analyse not only the legal ramifications of the proposal, but also its ramifications when understood as an exercise in political and hence moral philosophy. First, we need to understand the terms of the proposal to which I reply. The Commission's mooted Australian Human Rights Act contains several core propositions. A breach of the Act's rights will be justiciable through a specific positive duty imposed on public authorities to act compatibly with human rights and give proper consideration to human rights when making decisions. Public authorities limiting human rights must establish that their actions are proportionate. Parliament would be required to consider human rights when making and debating laws. These are all quotes from the consultation paper. The courts would be required to interpret all primary and subordinate Commonwealth legislation so far as is reasonably possible in a manner that is consistent with human rights, as stated in both the Human Rights Act and also international law. The Attorney-General must commence a review of the law wherever a court finds that legislation is incompatible and bring this finding to the attention of the Parliament. The Australian Human Rights Commission posits that this framework will ensure that, quote, human rights are embedded within the laws of our country. This is an issue in which I have some small personal familial stake. My great-grandfather was one of the drafters of the 1940 Sankey Declarations of the Rights of Man, considered the immediate precursor to the 1948 United Nations Declaration on the Rights of Man. Chosen for his recognition as a humanist and scientist, Sir Richard Gregory played the role of mediator between the principal drafter, his best friend, the cantankerous H.G. Wells, and the remaining committee members. Published just prior to the Blitz, the Sankey Declaration was attacked by Mussolini on the front page of the Popolo d'Italia and by Fritsch on Nazi propagandist radio for a week. A mixture of rights and duties, it had a seminal influence on the drafters of the 1948 Universal Declaration. However, since my great-grandfather's time, there has been a decisive shift in our understanding of the role of international human rights instruments within democracies. As Julian Rivers has argued, the original conception that human rights offer a code of international political morality binding on states from the outside, having no necessary domestic legal consequences, has faded. In its place, the assertion that human rights impose concrete, particular, domestically actionable requirements has assumed ascendancy. Rivers asserts that this internalising movement harbours an entirely different additional proposition. Judicial interpreters of human rights should be more or less equal in authority to the powers of democratically elected legislatures. In this first part of my lecture, I will argue why I consider that the ARA poses a quasi-constitutional resettlement, and in so doing, departs decisively from the understanding of our constitutional founders. In constructing the Westminster merger of the English and United States constitutional structures, our constitutional fathers avowedly eschewed any American-style Bill of Rights. As Greg Craven has said, the founders utterly rejected any notion that generalised guarantees of rights should be enforceable against the executive and legislature through the process of judicial review, consigning the vindication of such rights instead to Parliament itself. Noting the ARA does not grant judges the formal power to strike down laws as unconstitutional, I brought to the Parliamentary Joint Committee on Human Rights inquiry the following two core reasons why the passage of the ARA would present a profound alteration to our constitutional settlement. My first main concern is that the ARA will undermine confidence in the judiciary. This occurs in two main ways. First, because human rights are politically contested, canvassing matters such as the entitlements of suspected terrorists, restrictions in a pandemic, the limits of surveillance, the expression of religious views in public life, or more recently, the demands of environmental sustainability, judges can be seen to be taking sides in a political debate, thus undermining confidence in the impartiality of the judiciary and its independence from executive government. Such matters should be resolved through vigorous, democratically accountable parliamentary debate, not unelected and unaccountable judges. Moreover, claims in the name of human rights are frequently posited as a fait accompli, intended to conclude a debate, but closely observed are often simply another political claim amongst many. As John Griffith has said, abstract right formulations are the statement of a political conflict pretending to be a resolution of it. Second, the proposal requires judges to interpret Australian law against principles that are purposely abstract and imprecise, vastly enlarging the areas over which judges must determine the substantive content of the law in question and thus make law. Within the context of the Australian Human Rights Commission's proposal, this concern arises in two main ways. First, through the requirement that all Commonwealth legislation be interpreted according to the imprecise, abstract human rights stated in the ARA. Abstract human rights provide foundational framework principles which do not in themselves state what justice requires in any particular situation. Into the cavernous space between the abstract statement of a right and the particular circumstances of a complainant intrudes the unaccountable interpretive power of judges. In that movement, the delicate constitutional dance between Parliament, executive and judiciary is profoundly altered. The second way in which an ARA will require judges to determine the substantive content of the law in question is through the proposed General Limitations Clause, the mechanism for determining when a human right may be constrained. For this requirement, the ARA posits that limitations must be necessary, reasonable and proportionate. The potential of the proportionality limitations test to turn judges into lawmakers is plainly seen in the direction the test has taken under the United Kingdom's Human Rights Act of 1998, where judges declare multivariant principles for placing of restrictions on human rights without any substantive original direction from the legislature. As Francis Bacon famously wrote in 1612, judges ought to remember that the office is jus dicere, not jus dare, to interpret law and not to make law or give law. Judges ought to, above all, to remember the conclusion of the Roman 12 tables. Salus populi suprema lex. The supreme law of all is the weal of the people. and to know that laws, except that they be in order to that end, are but things captious and oracles not well inspired. My second chief concern is that because the proposal draws the judiciary into lawmaking, the ARA would undermine the proper function of Parliament. The difficult questions that arise in the context of human rights concerns should be the subject of the great contest of ideas that ensues in the public forum of Parliament as representative of the people, where their wide-ranging implications for all members of our diverse society can be properly considered and weighed. Instead, the ARA would leave the difficult matters that arise in the context of human rights claims to the courtroom, a setting only suitable for consideration of the particular circumstances of an individual claimant and respondent. Unlike a Parliament, a court is neither equipped nor able to take into account the full range of human rights implications of the particular claim for all groups within wider society. The courtroom cannot offer this panoramic deliberation, being geared to respond to the submissions of the parties in the particular matter before it. So understood, the ARA proposal disrupts the classical relationship between the three arms of government. It can thus be conceived as quasi-constitutional in nature, proposing a transferal of power from the Parliament to the judiciary, and as contrary to the confidence our founders held in parliamentary sovereignty. While the ARA thus presents a profound alteration in our constitutional settlement, it also presents as an exercise in political philosophy. Critically, like all political philosophy, it proceeds from certain assumptions about human nature and the means to attain human fulfilment through political ordering. For example, Montesquieu's classic formulation of the separation of powers proceeded from this understanding. It has eternally been observed that any man who has power is led to abuse it. So that one cannot abuse power, power must check power by the arrangements of things. Not only is our Constitution grounded in a certain view of human nature, owing to the cultural, moral and philosophical understandings that it instantiates, it also presents an exercise in political philosophy. Indeed, the circumstances surrounding the completion of the 1891 draft of our Constitution offer a very satisfactory symbol of our firm emplacement within Western political philosophy. The 1891 draft was finished not far from my home on the Hawkesbury River. My interest towards that event was piqued, as I have some small personal purchase in the Hawkesbury, recently learning to sail with my boy there. The drafters had set out from Port Jackson on Easter Friday, 1891, aboard the Queensland Government steamer, the Lucinda. The intent was, as Linnaeus describes it, to get away from reporters to a place where the vessel could lie in peace in the beautiful waters of the estuary of the Hawkesbury River. Barton described the Lucinda's anchorage at a most lovely place called Refuge Bay, replete, and it is beautiful, replete with a bush waterfall providing a natural shower bath, which Sir Samuel Griffith conceded that I did not take myself, inferring that others did. Of the resulting product, Linnaeus would say that the draft of 1891 is the Constitution of 1900, not its father or grandfather. Linnaeus recounts that an acute New Zealander discussing the results wrote that the D in Lucinda might very well have been dropped out of the name of the vessel with whose aid the federal constitution thus came to birth. Here Linnaeus refers to the Roman goddess Lucina, the goddess safeguarding the lives of mothers in childbirth. In this event, at the Easter birth of our Constitution, we find the curious placing of a symbolic direction to the two great philosophical traditions of the West, the Greco-Roman tradition and the tradition of Israel. The symbolism reminds us of the positioning of Australia within the dynamic tradition Tertullian famously coined when he asked in the 3rd century, "What then has Athens to do with Jerusalem, or the academy with the church. As Daniel Marnie summarises, these two great traditions present the dialectic of magnanimity and humility which has marked the West from the beginning and continues to operate within our liberal dispensation. As the philosopher Leo Strauss, following Nietzsche, emphasised, this unresolved conflict between these two great traditions is the secret of the vitality of Western civilisation. For we must be aware of the fact that the vitality and the glory of our Western tradition are inseparable from its problematic character. The symbolism of the drafters' efforts on board the Lucinda or Lucina over the Easter weekend of 1891 offers to us a fitting reminder of Australia's emplacement within this deep continuum definitive of the West, and hence an example of how our Constitution is an exercise in political philosophy. To return to the debate over the ARA, I want to argue that the proposal enlivens another continuum characteristic of Western political philosophy, again, one whose trajectory oscillates between two poles, that of universalistic human rights on the one hand, and that of local concrete bonds of relationship on the other. To understand the philosophical underpinnings of the ARA as a modern-day expression of the former pole, the universalistic human rights pole, we need to observe an intellectual lineage coursing through the writings of Immanuel Kant, Montesquieu and Rousseau to the Australian Human Rights Commission of our time. As I will show, it is a lineage against which significant challenges have gathered, not least among them Edmund Burke and Alexis de Tocqueville. Kant's excitement at the French Revolution is well known. In his idea for a universal history with a cosmopolitan purpose, Kant channeled the utopian universalism characteristic of his time when he claimed that the contemporary upheavals ultimately expressed in the French Revolution, quote, indirectly prepare the way for a great political body of the future, without precedent in the past. This encourages the hope that after many revolutions, with all their transforming effects, the highest purpose of nature, a universal cosmopolitan existence, will at last be realised as the matrix within which all the original capacities of the human race may develop. On this basis, Kant asserted that philosophy too may have its chiliastic expectations. Chiliasm being the Christian belief in a coming millennium of global harmony. However, as Oliver O'Donovan, in reply to Kant, recently asserted, the posit of universal human fellowship is irreconcilably in contradiction to the concrete and bounded spheres of communication that we actually live in. If we ignore the role of place, the idea of society can hardly fail to become threatening to freedom. This was the nakedly imperial idealism of Kant's demand for a universal federation. When society is understood as a total system, it assumes the claims of overriding necessity. Against Kant, O'Donovan asserts, in sealing the identity of a society, place protects it against totalitarian pretensions, as Kant expressed. Kant's universalistic idealism found its expression in the 1789 Declaration of the Rights of Man and of the Citizen. Burke contends that in Rousseau, the authors of that 1789 document found that peculiar vice which they wished to erect into a ruling virtue. Burke said, "It is that new invented virtue which your masters canonise that led to their moral hero constantly to exhaust the stores of his powerful rhetoric," this is Rousseau, "in the expression of universal benevolence, whilst his heart was incapable of harbouring one spark of common parental affection. Benevolence to the whole species and want of feeling for every individual with whom the professors come into contact form the character of the new philosophy. I've been enjoying introducing my 13-year-old daughter to philosophy through the paragon of contemporary thought, Taylor Swift. Swift, whether she is conscious of it or not, her claim that a friend to all is a friend to none succinctly summarises Burke's charge against Rousseau. As Leo Strauss notes, against this principle of universal benevolence, Burke asserts that it is to be attached to something means to care for it, to have a concern with it, to be affected by it, or to have a stake in it. Burke's insight was that theoretical, platitudinous notions of universal benevolence endanger actual moral obligation. Theory is liable to endanger full devotion to practice. As Burke wryly observed, philosophical speculators ought to be neutral. A minister cannot be so. In the transformation heralded by Republican morality, all natural sentiments must be ruthlessly sacrificed to the alleged requirements of patriotism or of humanity. It is for this reason that against the universalist and dissipating presentiments of the French revolutionaries, Burke famously held up faith in the capacity of the little platoons as the first link in the series by which we proceed toward a love to our country and to mankind. Tocqueville joined Burke in expressing the same insight in his Democracy in America. Whereas the aristocratic social order inculcated personal obligations of charity, democracy and equality occasioned isolation. Tocqueville wrote, "So men who live in aristocratic centuries are almost always tied in a close way to something that is located outside of themselves, and they are often disposed to forget themselves. It is true that in these same centuries the general notion of fellow is obscure and that you scarcely think to lay down your life for the cause of humanity, but you often sacrifice yourself for certain men. In democratic centuries, on the contrary, when the duties of each individual toward the species are much clearer, devotion toward one man becomes more rare. The bond of human affection expands and relaxes." Both Burke and Tocqueville held out the association as the response to this alienating democratic tendency. Their insights are interesting because they sat at the cusp of the modern age and modern democracy, so they were able to view back into the centuries that came before them in a much clearer fashion than we can. This continuum of tension within the modern West between universalising human rights principles and the concrete and bounded spheres of communication that we actually live in, to some degree explicates for us the unswerving opposition by some to associational and religious exceptions within discrimination law. But that is an analysis that will have to await another day. For today's purposes, I wish to assert that it is upon the universalistic pole of this spectrum that the era of 2024 is firmly ensconced. O'Donovan's critique of Kant's chiastic idea for a universal history with a cosmopolitan purpose is that totalitarian pretensions attend the universalist pole of the human rights pole of the continuum. In a parallel manner, Montesquieu offers a subtle critique of the democratic republic, where all private virtue stems from the love of the republic, which produces all the individual virtues. Burke reached the same understanding. The French Revolution is a revolution of doctrine and theoretic dogma, he said. Are we correct to hear echoes of such chiastic confidence when the current president of the Australian Human Rights Commission assures us that the ARA will support a cultural shift towards rights-mindedness, becoming part of the national psyche? In making your assessment, I again invite you to consider Burke's critique that the French Revolution presented a philosophic revolution, seeming to have extended even to the constitution of the mind of man. The interaction of how these foregoing jurisprudential and philosophical concerns brings me to this concluding question. Have we forgotten the raison d'etre of the constitutional separation of powers? In covertly penning Master and Margarita at the height of the Stalinist purges, Mikhail Bulgakov sought to illuminate for us a direct intellectual lineage coursing from Kant's philosophy to Stalin's dictatorship. Bulgakov has his chief protagonist proclaim, "Your interlocutor, the devil, was at Pilate's, had breakfast with Kant, and now he's visiting Moscow." In so doing, Bulgakov provides to us a piercing insight into the trail of destruction, fear, and broken harmonies that follow unfettered human power. It was Marx's failure to understand Montesquieu's insight that the need for a constitutional separation arises precisely because of the human desire for power, which laid the seeds for the Stalinist regime that Bulgakov critiques. For the reasons I have set out, it is this foundational principle of a separation of powers which the ARA now proposes to alter. So to conclude, my title promised you a critique of pure human rights reasoning. I have offered you a critique in the sense adopted by Kant in his The Critique of Pure Reason, by which is meant a study in the presuppositions of human understanding. In this case, a study in the presuppositions of modern human rights understanding. I have also offered you a critique in the modern sense, by which is meant a criticism of those presuppositions. I have expressed the concern that, while human rights can legitimately convey accepted statements of international consensus, attempts to import these abstract ideals into domestic legislation will inspire a continual grappling for human rights trump cards over contested political issues. Further, as I've shown, an ARA lends itself to outcomes that are not consistent with the principle of the separation of powers that underpins our democratic system of government. As Burke and Tocqueville so cogently understood, rather than placing our hopes in the abstract universalist principles of the philosophical speculators of the French Revolution, we do well to recall that it is within place, within the concrete and bounded spheres of communication that we actually live in which lies the hope for our continued meaningful experience of that classical triumvirate of the good, the true, and the beautiful. Finally, I want to close with the words of this Society's inaugural president, with which I think aptly summarise my concern. If society is tolerant and rational, it does not need a Bill of Rights. If it is not, no Bill of Rights will preserve it. Thanks very much.